So we're gonna go ahead and get started. So I'm Greg Oblowski. I'm a legal historian here at the law school, but I find myself mostly a sort of 18th, early 19th century legal historian. But I have been dragooned into chairing this panel on the Reconstruction era outside my comfort zone. Ooh, mood lighting. I guess reflecting my own darkness on the topic, we have four people who are going to illuminate this question for us. So on my right, we will proceed in this order. So Kurt Lash is joining us from the University of Richmond. Then we have Elon Werman from ASU, and then Larry Lessig from Harvard, and Reva Siegel from Yale. So they are all going to speak for perhaps slightly more than 10 minutes apiece, and I think we're really going to be picking up the baton from what Will flagged for us. The illumination has already begun. So they're going to be picking up from what Will has teed up for us, this question of the 14th Amendment, particularly the Privileges and Immunities Clause and its meaning. So, Kurt, I'll pass it over to you.
All right, thank you very much. Great pleasure to be here. Wonderful conference. Thanks to Michael McConnell and the folks at the ConLaw Center for putting this together. I'm very honored to be on the panel talking about history and the 14th Amendment. I'm especially glad to be on a panel where I'm not the only person who thinks that slaughterhouse was correctly decided. That has to be a first among the ConLaw programs that I've been involved with. I think that slaughterhouse is correct because I think Justice Miller's opinion is consistent with the constitutional theory of Republicans in the 39th Congress in general and the ideas of John Bingham in particular. Slaughterhouse doesn't tell us everything we need to know about the privileges or immunities of citizens of the United States, but it does tell us many things that are true. For example, Justice Miller distinguishes the state law secured privileges and immunities of Article 4 from the national privileges and immunities of the 14th Amendment. That point, I think, is textually unassailable. They're worded differently, and as John Bingham explained, they cover different kinds of rights. The rights of state citizenship are different than the rights of national citizenship. So what are the rights or privileges of national citizenship? Well, according to antebellum Republican abolitionists like Joel Tiffany, the privileges or immunities of citizens of the United States are those listed in the Bill of Rights, the First Amendments to the Constitution. Southern states had repeatedly denied American citizens, black and white, these basic enumerated rights. Prior to the Civil War, however, Congress had no power to force states to respect the National Bill of Rights, and in the opening days of the 39th Congress, John Bingham announced his intention to change this. Here's how Bingham described his first draft of the Privileges or Immunities Clause. Quote, "The proposition pending before the House is simply the proposition to arm Congress with the power to enforce the Bill of Rights. As it stands in the Constitution today, it hath that extent no more." When the final draft went to the states for ratification, Bingham continued to publicly declare that the clause would enforce the Bill of Rights against the states, including provisions like those in the Eighth Amendment. Now, as a quick aside, as we get into this, a while back the late Pauline Maier gave a speech in which he suggested that Americans might not have used the term Bill of Rights as a reference to the first 10 amendments until the 20th century. She had discovered, correctly, a number of instances where antebellum Americans had referred to the Declaration of Independence as the American Bill of Rights, and since her speech, a number of scholars have repeated general claims. However, it turns out that antebellum Americans, in fact, referred more often to the 10 amendments as the American Bill of Rights on a ratio of at least 15 to 1. And I'm publishing the empirical evidence on this point in the next edition of Virginia Law Review. My only point in bringing that up is that when Bingham announced to the public that his efforts were directed at enforcing the Bill of Rights against the states, the public knew what he was talking about. There's no evidence, however, that Bingham or any of the other moderate Republicans wanted to authorize either current or future courts or legislatures to entrench unenumerated rights not debated by the people themselves in their highest sovereign capacity. The moderate Republicans in the 39th Congress believed in the principles of American popular sovereignty, the right of the people to debate constitutional change and decide for themselves whether to add new rights to the Constitution. For example, again, here's John Bingham explaining why Congress could not act until they first ratified the 14th Amendment. Quote, quote, "It is the power of the people of the United States to take such security in their judgment they may deem effectual for the future safety of the Republic and the protection of the rights of all the people of the Republic. This is a right that belongs alone to the people, and which can be exercised effectively only by the people." The idea that entrenched rights might suddenly appear by way of legislative or judicial fiat without this kind of national sovereign conversation is obviously in tension with that theory of Reconstruction-era theories of popular sovereignty. Most Republicans in 1866 also would have opposed nationalizing broad, unenumerated categories of local common law rights. That would have had the effect of obliterating American federalism, another basic Republican principle at the time. There's a reason why Justice Miller in the Slaughterhouse cases believed that the 14th Amendment should be interpreted in a manner preserving the basic Federalist structure of the Constitution. Mainstream Republicans in 1866 would not have passed any other kind of amendment. Republican constitutionalism at that time, believe it or not, deeply respected and accepted the visions of the Federalist Papers as canonical guides to understanding the proper structure of American government. It had been the Calhounian South that had betrayed this original Madisonian Constitution. I've just published the first of a couple of articles demonstrating the use of the Federalist Papers in political rhetoric between the time of the founding and the Civil War, and it's absolutely remarkable how much use you found in that political rhetoric and how influential essays like Federalist 45 were in the debates of the 39th Congress. Both Republicans and Democrats regularly quoted the 10th Amendment positively, and Bingham, keeps taking me out here, and Bingham especially was devoted to Federalist 45. Here is Congress explaining why it was important to actually pass an amendment enforcing the Bill of Rights against the states. He says, I beg leave to read in confirmation of the truth of what I say, an utterance made in the hearing of the whole people of this country in 1788, when the Constitution was on trial for its deliverance. I read from number 45 of the Federalist, a paper written by James Madison. The powers reserved to the federal states will extend to all the objects which in the ordinary course of affairs concerns the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. Bingham quoted that because it was his position that they should enforce the Bill of Rights against the states, but at that time, Barron v. Baltimore, the court's decision in 1833, prevented the enforcement of the Bill of Rights. It was going to take, under the Federalist Constitution, Congress lacked the power until it went ahead and added an additional amendment. In the end, the moderate Republicans drafted a clause that empowered Congress to protect the already existing enumerated rights of American citizens and ensure that every person, citizen or not, received the basic natural rights of due process and the equal protection of the laws. That preserved the basic Federalist structure of the Constitution while also recognizing the role of the Bill of Rights in Reconstruction-era Republican constitutionalism. And this is fully consistent with Miller's opinion in Slaughterhouse. Now, the idea that the Privileges or Immunities Clause protects only constitutionally enumerated rights is not a new idea. It was Justice Hugo Black's idea back in Adamson against California and in Duncan against Louisiana. Justice Black, some of us recall, rejected the doctrine of substantive due process, and he insisted that the Privileges or Immunities Clause was the proper textual vehicle for the incorporation of the Bill of Rights. I've long been a fan of Justice Black's total incorporation approach in Adamson and Duncan. Unfortunately, nobody else seemed to be. So naturally, I was very pleased to see Justice Black make an appearance in footnote 22 of the Dobbs decision. In that footnote, Justice Alito explains that the majority's history-based analysis would be the same, whether done under the Due Process Clause or under the Privileges or Immunities Clause. Then, as examples of this historically rooted reading of the Privileges or Immunities Clause, Alito cites two opinions: Justice Thomas's concurring opinion in McDonald against Chicago, and a cite to Justice Black's opinion in Duncan against Louisiana. In that opinion, Justice Black doubled down on his Adamson dissent and its history-based reading of the Privileges or Immunities Clause in its citation of the views of John Bingham and its protection of nothing more than the enumerated rights previously listed in the 10 Amendments to the Constitution. To my knowledge, Alito's Dobbs citation to Justice Black's Duncan concurrence is the first time any Supreme Court majority has cited Justice Black's theory of incorporation. In that same footnote, Alito also cites Justice Thomas's opinion in McDonald, where Thomas, according to the parenthetical, reserves the question whether the Privileges or Immunities Clause protects any rights besides those enumerated in the Constitution. And then in his separate Dobbs concurrence, Justice Thomas notes that one of the first questions the court would have to answer if it moves to the Privileges or Immunities Clause is whether that clause protects any unenumerated rights at all. Thus, the future debate whether the Privilege or Immunities Clause protects unenumerated rights has begun with citations to a doubting Thomas and the very anti-unenumerated rights opinions of Justice Black. If the court continues its slow turn to the Privileges or Immunities Clause, the first stop might be a decision that shifts incorporation of the Bill of Rights to the Due Process Clause and into the Privileges or Immunities Clause, does so with a quick citation to Justice Black and involves no discussion of slaughterhouse whatsoever, because none will be needed. If the court wants to go further, they'll have to work through the quickly multiplying theories of unenumerated privileges or immunities and whether these involve natural rights or Lockean rights or common law rights or deeply rooted rights or libertarian rights or general citizenship rights or unwritten general law rights, which I think was Will's proposition during the lunchtime presentation, or something else. Whether the court can do this in a manner consistent with originalism and the basic theory of popular sovereignty remains to be seen. All right. One final point about the future of Section 1 of the 14th Amendment. To date, the court has focused almost all of its jurisprudence on the last two clauses of Section 1, the due process and equal protection clauses. The court has left the opening three citizenship clauses unexplored and unenforced. The opening section of Section 1 states, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." That national citizenship clause, the opening, echoes the opening of the 1866 Civil Rights Act. The second clause, the state citizenship clause, was altogether new, and it was added only at the last minute. Scholars and courts to date have ignored the state citizenship clause, but at the time it was considered extremely important, especially to Black Americans in the South. For example, here's an 1866 editorial in the Black American newspaper, the New Orleans Tribune, discussing the proposed 14th Amendment. Quote, "Let us only consider the first section. All persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This doctrine is the correct one. It was absurd to tell a man you're a citizen of the republic at large, but you have no rights in your own state. You're not even a citizen. Every man of African descent is not only declared to be a citizen of the state wherein he resides, but he will be entitled to the same privileges and immunities as any other citizen. In other words, all classifications among citizens must fall. Legislation must consider all classes of citizens as forming one single mass, for which all laws must be equal. No discrimination can be made in the future either on account of color or on account of naturalization and origin. Every title of citizenship is declared to be of like value and to confer the same rights." This is just one of many similar statements that were made during the ratification debates that I present in the paper which I posted for this conference. And if this represents a consensus understanding of state citizenship, then this could have significant implications for the future development of equal rights jurisprudence. It may be that cases like Brown v. Board are better viewed as cases dealing with the original understanding of the rights of equal state citizenship. That was Justice Harlan's view, of course, and we may start seeing more citations to his work as well, alongside citations to Justice Black. and hopefully more citations to the ideas, to the man that Justice Black called the Madison of the 14th Amendment, John Bingham. Thank you.
Great. Well, thanks so much for having me. I'm going to have to pull a little bit of an audible because the very last thing Kurt talked about, state citizenship, is what I was planning on sort of responding to because that was the paper. But it'll be responsive more broadly. And so the paper that I'm talking about or presented for this paper is called Reversing Incorporation. Yes, a play on reverse incorporation, where I cast, I'm skeptical of a lot of the historical literature that purports to support incorporation of the Bill of Rights against the states. So let me start with what I think are the 5 possible meanings of the Privileges or Immunities Clause. There are a few others, but these are the principal 5, and then we'll go from there. The first is that it incorporates the Bill of Rights against the states, and that's really all it does. The privileges and immunities of citizens of the United States are those in the federal Constitution, so it could include habeas, more than just the first 8 amendments, but principally the first 8 amendments. Until Kurt's state citizenship paper, I thought that was his view, and I'm not sure anymore. The second possible view is that it is an absolute guarantee of all fundamental rights, including the rights in the first 8 amendments, but also contract and property rights, the stuff of Lochner against New York. A third possible view is that the clause refers to all of these rights. They're all fundamental rights that all free governments must secure, they're privileges of citizens. But what it means to abridge them is it means to invidiously discriminate in their provision. So it's an equality guarantee. It's not an absolute guarantee, it's an equality guarantee with respect to those rights. The fourth possibility and fifth possibility is sort of a fusion of these two. One is that it is a fundamental floor guarantee of all of these rights, but also an equality guarantee of these rights above whatever that floor is. This is, I take to be Randy Barnett's and Evan Bernick's view. And then the fifth, which I thought I was going to hear Kurt talk about today, but he didn't, is what I call this two-tiered theory, or I think Akhil Amar has called a two-tiered theory of the Privileges or Immunities Clause, by which it is a fundamental guarantee of some of the privileges and immunities of citizens, namely those in the Bill of Rights, but it is merely an equality guarantee with respect to the others, like contract and property, thus we avoid Lochner. Okay. So what I want to do is 2 things. One is I want to narrow from these 5 what I think are the 2 plausible candidates based on the text and overall purpose of the amendment. And from there, my paper tries to whittle down which of these 2 is correct, and I think it's the equality reading. But starting with the 5 to 2 plausible theories, Kurt in his paper talks about, he didn't talk about it here, so let me just back up and backfill a little bit. A lot of these provisions these provisions of the 14th Amendment, this is what I argue in my book on the 14th Amendment, are written in legal language, and these solve the problems that the framers were confronting, a principal problem being the Civil Rights Act, which has been alluded to several times. Annie Koppelman mentioned also in the previous panel. The Civil Rights Act of 1866 begins with a declaration of United States citizenship, and then says, such citizens, okay, such, a cross-reference back to citizens of the United States, okay, such citizens of every race and color shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, convey, hold real and personal property, as is enjoyed by white citizens. Okay? It is an equality guarantee with respect to these fundamental rights traditionally regulated under state law. Okay? That's what the Civil Rights Act does, but we need a constitutional basis for it, and even if the 13th Amendment is a constitutional basis for it, what happens when the Democrats take over, which they did in 1875? What's to stop them from repealing the Civil Rights Act of 1866, so we need to enshrine it in the fundamental law. We know the 14th Amendment does it. The big question is, what provision in the 14th Amendment does it? Everyone says, oh, equal protection, but that's not true. That's not correct, because as Kurt talks about in his paper, and I've talked about before as well, protection of the laws was actually a narrower legal concept. I guess I flagged this for you guys in the question in the 2 panels ago, where it was judicial, it was principally concerned with protection against private invasion of private rights, so judicial remedies against private parties that invade your life, liberty, and property rights, and protection from physical violence, like the Ku Klux Klan. So you can have totally unequal rights, as African Americans did, and as women did. What protection of the law says is, whatever rights you have, though, we'll make sure you can exercise and enjoy those rights free of Ku Klux Klan violence. That's sort of an example. So what constitutionalizes the Civil Rights Act of 1866? It has to be the Privileges or Immunities Clause. That's the only thing that's left. Now, the question is, does the Privileges or Immunities Clause language does the necessary work? It does. It does. Why? What are the privileges and immunities of citizens of the United States? They told us over and over again in the historical record that these are the rights that all free governments must secure, not just the kinds of rights that are protected in the first 8 amendments, but also contract and property rights and the like. So start with the Civil Rights Act and Andrew Johnson's veto of the Civil Rights Act. He said the act gives to African Americans, to the freed people, the privileges and immunities of citizens of the United States. What are these privileges and immunities of citizens of the United States? Johnson goes on to say, the right to make and enforce contracts and to acquire property, right, and so on. So that's one. Schuyler Colfax, Speaker of the House, Lyman Trumbull on the campaign trail, they were asked, what are the privileges and immunities of citizens of the United States? They said, we defined it in the Civil Rights Bill. Then we enacted it in 1866. And then, of course, John Bingham himself, who Article 4, we all know, well, I see some students here, Article 4, the Privileges and Immunities Clause, guaranteed contract property rights to other state citizens when traveling in a particular state. So it was an interstate non-discrimination provision. John Bingham thought that this secured the privileges and immunities of citizens of the United States. This was his ellipses reading, right? The citizens of each state, being ipso facto citizens of the United States, shall be entitled to all privileges and immunities of citizens of the United States in the several states. That's what John Bingham said in 1858, in 1859, in 1866. He changed his mind in 1871, 6 weeks before. He still maintained the first line that he had always maintained. But he did change his mind in 1871. So we have Bingham, Colfax, Trumbull, Andrew Johnson, all these important Reconstruction figures telling us privileges and immunities of citizens of the United States include contract and property rights. Other rights too, like those protected by the first 8 Amendment. The question then becomes, what does it mean to abridge those rights? And I submit that abridge does the work of equality. Right? Michael, I think, mentioned this, to abridge is to give a shortened set of rights. So abridged was often used in the context of we have an abridged set of rights vis-a-vis a most favored nation, a most favored class of citizens. So abridged does the equality work. Now, you can also abridge from a floor. You can abridge from a fundamental baseline. I don't deny that. But that leaves, of the 5 things I talked about, only 2 plausible candidates for the meaning of the Privileges or Immunities Clause. We know incorporation only can't be right, because that doesn't get us the Civil Rights Act. We know a fundamental guarantee of all rights alone doesn't get us the Civil Rights Act, because you can discriminate above the floor, so that doesn't work. So the equality reading does work, okay? That's one possibility. And the other possibility is it is a fundamental floor with respect to all of these rights and an equality guarantee above that floor. That might get us Lochner, but that doesn't mean it's wrong. Doesn't mean it's wrong, okay? I forgot to mention the 5th thing, the 2-tiered theory that until today I'd only seen defended by Key Lamar in a brief passage in his book on Bill of Rights and Reconstruction, and that I took Kurt's paper to be defending. I think the 2-tiered theory is indefensible, because whatever work a bridge does, it must do with respect to all of the privileges and immunities of citizens of the United States. It's not a bridge does fundamental rights work with respect to some subset of them, those in the first 8 amendments, but only equality with respect to others, contract and property. Whatever the work a bridge does, it must do to all of these rights, okay? Now, I think, Kurt's paper to be saying, well, equality in state citizenship rights was itself a privilege and immunity of citizens of the United States. But the problem is it wasn't. That's why you needed the 14th Amendment. The 14th Amendment makes equality a fundamental right by saying no state can abridge, discriminate in the provision of these privileges and immunities, which include contract and property rights. So I think that leaves only 2 possible candidates. This equality-only reading and the fundamental rights plus equality with respect to all of these rights. Now, this paper tries to figure out which of these 2 is more plausible based on the historical record, and I think that the evidence for the fundamental rights incorporation reading is pretty minimal, actually, and I think that a lot of legal scholars who have done this have engaged in a series of historical errors, methodological errors. They engage in this conflation where every time the first 8 amendments, I'm doing it myself, the rights mentioned in the first 8 amendments happen to be mentioned in the historical record. They take it as a reference to the first 8 amendments, but it's not. These are the kinds of, so in other words, every time the freedom of speech was mentioned, they must be talking about the First Amendment. Or every time the right to bear arms is mentioned, aha, they must be talking about the Second Amendment, and they must want to incorporate. But no, these are the kinds of rights that all free governments had to secure, and simply mentioning them doesn't tell us what we're talking about. Article 4 secured these rights, the Republican Guarantee Clause secured these rights, the First Aid Amendment secured these rights. That doesn't tell us how they secure them, against whom they secure them, and so that's sort of the question. So let me give, and I promise I've been going 10 minutes now, so let me give 3 quick examples and then conclude with Jacob Howard. Example 1. Both Akilah Marr and Michael Kent Curtis, in their work on incorporation, cite a pamphlet from Senator Plumer, writing as Cincinnatus, attacking a Calhoun position that the northern states should abolish or should prohibit abolitionist literature. They cite the pamphlet for the proposition that neither the United States nor any state may abridge the freedom of speech, and Michael Kent Curtis and Akilah Marr strongly imply that they were therefore barren contrarians. They thought the First Amendment already applied against the states. But if you read Plumer's pamphlet, he cites every single state constitution's First Amendment equivalent. And he says if these mean what the First Amendment means at the federal level, then neither the United States nor any state may abridge the freedom of speech. That's example 1. Example 2, there was a lot of discussion about how slavery leads to a suppression of civil liberties such as the freedom of speech and press, and they make it sound as though this leads to this desire to incorporate the Bill of Rights. But on the contrary, these debates were in the context of the 13th Amendment, and no one thought that the 13th Amendment abolishing slavery incorporates the Bill of Rights against the states. What they thought was that the southern states suppressed freedom of speech and suppressed the right to bear arms and suppressed liberty because of the presence of slavery, as an incident of slavery. And once slavery is destroyed, freedom will be restored, will be resurrected because of the 13th Amendment. And again, who's doing the restoration? The southern states will no longer need to suppress speech and guns and so on. That has nothing to do with incorporation. Example 3, a lot of this was in the Republican Guarantee Clause context, where they said, well, we're not going to admit the southern states back into the Union because they're not Republican. Why are they not Republican? Well, they don't guarantee free speech to the free people. They don't guarantee the right to bear arms. Again, that says nothing about what happens when they're readmitted. Okay, let me conclude with this statement from Jacob Howard, which even Charles Fairman, thought was the best evidence against the position that I'm advancing today. He said, what are the privileges and immunities of citizens of the United States? He said these are the rights of Article 4, and then he cites Corfield v. Coryell, contract property, and so on. To these should be added the rights, the personal rights, secured and guaranteed by the first 8 amendments of the Constitution, and then he lists all but 2 of them. Okay, what has Howard done here? He simply identified what are the privileges of citizens of the U.S. All the rights that all free governments must secure, including speech, press, the right to bear arms, contract property. So far, he hasn't told us anything about what it means to abridge them. And let me propose that there are 2 possible ways to abridge them. One is the Privileges or Immunities Clause is a guarantee like the first 8 amendments, an absolute guarantee, or it could be an equality guarantee like Article 4. So let me conclude with 2 quotes, one about Article 4 and one about the Civil Rights Act. So John King in 1871 described Article 4 as securing the privileges of citizens of the United States, including the rights specified and enumerated in the federal Constitution. How does it secure them? By guaranteeing equality to citizens of other states. The states without Article 4, by their local legislation, might and perhaps would impose different restrictions on the residents of each other, militating against these unalienable rights. Civil Rights Act, Lyman Trumbull, in defending it, he says, each state, so that it does not abridge the great fundamental rights belonging under the Constitution to all citizens, may grant or withhold such civil rights as it pleases. All that is required is that, in this respect, its laws shall be impartial. So here we have the 2 predecessors, the precursors to the Privileges or Immunities Clause, Article 4 in the Civil Rights Act. Both were understood to guarantee the privileges and immunities of citizens of the United States, and both were understood to guarantee those privileges and immunities by requiring equality. Thank you.
So the fall of the Reconstruction Empire, it is said, began with the slaughterhouse cases. A willful court, as the understanding goes, self-consciously misread a core clause of the 14th Amendment, the Privileges or Immunities Clause, to render it useless. And useless, of course, it remains, except for tiny problems that none would believe that Bingham or the Republicans or the people were essaying to solve in a constitutional amendment. Yet I want to suggest that history has now given us a way to read that opinion differently, and constitutional theory gives a way to make that reading relevant today. So let's start with the history. In his student note, my colleague Nico Bui gave us an account of a common understanding among those who drafted the 14th Amendment about what a privilege and immunities clause was. Building on the work of Kurt, his articles, his book had just come out before Nico's essay, Nico described a legal culture that had practiced a special facility with privileges or immunities clauses. That facility was that both courts and legislatures were empowered to line the contours of the protections such clauses were meant to afford. A court might determine that a certain right was within the scope of the clause, but so too could a legislature, by a law, determine that a certain right was within the scope of that clause. Determine in the sense of first recognizing the existence of some right based, as Judd described yesterday, in either customary or natural law, and then making it particular through some positive act, a judgment by a court, or positive law, a statute, as Judd described yesterday. The Seventh Amendment determined the jury right in that it recognized there was such a right within our tradition, but then made the specifics of that right real in the specification of $20 as its trigger. In this sense, then, a court might determine that a right was a privilege or immunity, say the right to travel across state borders, and in this sense, then, a legislature might determine that a right was a privilege or immunity, say, as Congress did in 1870, when it reenacted the Civil Rights Act of 1866, thereby re-rendering the rights determined in that law as privileges or immunities of citizens of the United States. So what are the conditions within a legal culture, or the presuppositions of a legal culture, that could make such a practice make sense? I would suggest that those conditions are well described by Will and Steve and Judd in their recent and powerful article on general law, because in describing the practice of general law lawmaking, Will and Steve and Judd are evincing a certain capacity within that legal culture, the capacity to determine whether a particular right was or was not a privilege or immunity. That capacity was a kind of practical facility or ability that people acquire through a certain kind of training against the background of certain beliefs. The belief, for example, that there was such a thing as natural law that might provide the grounding authority for determining rights. In that world, the regime that Nico describes makes perfect sense, given this common capacity, common between courts and legislatures. It makes sense that either courts or legislatures could determine privileges or immunities, just as either a court or a legislature could determine the 52nd integer in a Fibonacci sequence. And so that's what in 1870 Congress did by reenacting the Civil Rights of 1866, and that's what in 1873 the Supreme Court did in deciding the particulars of the slaughterhouse cases. Now, viewed like this, Miller's opinion begins to make a whole lot of sense. Because viewed like this, Miller is essentially saying this: look, there are certain rights we'll interpret as plainly within the scope of privileges or immunities. You all know what this list is, those, quote, which owe their existence to the federal government, its national character, its constitution. Those would include the weirdly weak right to visit an embassy. They might also include the Bill of Rights, as the opinion hints. But beyond those, quote, federal government, national character, constitution rights, Miller told us a federal privilege or immunity could come from Congress's law, quote, or its laws, end quote, as the sentence I quoted above actually ends. And what was an example of such a law? Again, the Civil Rights Act of 1866, reenacted in 1870. Viewed like this, Miller is simply saying, we've got some of this covered, but if you want more rights to be enforceable, through the Privileges or Immunities Clause, then you, Congress, need to act first. And if you do go first and enact a law within the scope of privileges or immunities, then we will enforce the rights under that law as a privilege of United States citizenship. That, I suggest, is a wildly reasonable balance for a court to strike, affirming as it does a clear constitutional minimum, but leaving the difficult question of unenumerated privileges to Congress to enumerate. This is a fidelity to role, limiting the scope of meaning that the court itself will determine. But here is the critical point. It is a mistake, and it's a mistake that almost all originalists make, or all one-step originalists make, but also a mistake of historians when they think that the work of application is finished once the work of history is done. It is a mistake to go from this is what they did to we can do the same thing today. Just as you can't clip off a branch of coral from the Great Barrier Reef and expect it to thrive next to your tulips, you can't snip a bit of practice from the middle of the 19th century and expect we can engage the same practice today. Whether we can depends upon our training and what we believe. And if, to invoke a familiar quote, law in the sense in which courts speak of it today does not exist without some definite authority behind it, and if we've lost the capacity to believe that there is definite authority behind this practice, what Will Smith and Judd called general law, then we don't have the ability today to do what they did then, because given how we view the law today, there would be too little to constrain the practice of determining which rights are within the scope of privileges or immunities and which rights are without it. You might say that we lawyers are like priests who have lost their faith, a faith in general law, but kept their jobs. And so the question is how we atheists, in this jurisprudential sense, translate the 19th century practice into today. Seems to me there are three choices. The first choice is to simply go home, to declare, contrary to the history of the Privileges or Immunities Clauses, that there's nothing new that can be added to the privileges or immunities of citizens of the United States through the Privileges or Immunities Clause, that maybe we can fill out the Bill of Rights as privileges or immunities as they plainly intended they would be, and as Slaughterhouse itself hinted they would be, and as would be consistent with the original meaning, but beyond that there would be nothing more. The second choice would be to continue the practice of allowing both Congress and the court to determine privileges or immunities. What they would be doing would not be what their 19th century ancestors had been doing, for their ancestors had not lost their faith as we have, and so they would have been constrained in the way that we could not be. Or finally, as the third choice, we could imagine one of these two institutions, Congress or the court, charged with articulating the evolving privileges or immunities. That's what the court has done today. Bernie makes it the exclusive arbiter of privileges or immunities of citizens of the United States. But I suggest this is exactly the wrong choice between these two institutions. Because for the same reason that Erie was right to remove federal courts from the practice of determining federal general common law, it would be wrong for the Supreme Court to occupy the role of determining an evolving scope of the Privileges or Immunities Clause. Given how we speak of law today, this highly politically charged policy determination is precisely what a court should not engage. That's the teaching of fidelity to role, and thus it follows that if any institution should be in the role of determining an evolving scope of federal privileges or immunities, or more precisely, elevating such rights to uniform and federal protection, it should be Congress, not the courts. This is thus another example of what I described 25 years ago as an Erie effect. It is a reallocation of institutional authority forced onto the system by a changing understanding of the nature of law. And we know it is not just from a careful, and we know it not just from a careful reading of the text in context, as Kurt has given us, and not just, as Jonathan counsels, from the careful explication of a conceptual universe the framers of that text occupied, but from translating the meaning of that text in its context to our context today. It is thus not just text and not just history, but it is a third thing, and a critical thing missing from the title of this conference, constitutional theory, added to both. That theory teaches us how much of what they did we can do today, and it guides us in how authority must be reallocated given what we believe today. Thank you.
So I want to thank Michael for organizing this really extraordinary conversation and for the perhaps mischievous decision to invite me to partake in it. My question today is, does the court's decision reversing Roe in Dobbs rest on originalist reasoning? On what grounds and by what criteria would we decide whether a practice is originalist? And what are the stakes? To address these questions, I'm going to briefly talk about my recent article, Memory Games, Dobbs's Originalism as Anti-Democratic Living Constitutionalism, and then go on to discuss a forthcoming prequel to this story. So we know that there are originalists who've objected that Dobbs is not originalist, and in a recent article, which we heard about at lunch, Professors Randy Barnett and Larry Solomon observed that Dobbs is anchored in due process law. It is doctrinal, yet it contains certain originalist elements, including the opinion's passing engagement with the 14th Amendment's text, the claim that the Constitution is silent about abortion, and the opinion's repeated reference to the number of states that banned abortion in 1868. They argue that Dobbs is pluralist and hybrid because Dobbs does not conform to the practice of to the interpretive methods practiced in the legal academy today, specifically original public meaning originalism. In Memory Games, I compare two different understandings of originalism. The most common view in law, or meta view in law, is that originalism is an interpretive method or a family of interpretive methods that claim to be value neutral. I contrast this with the view that is perhaps more common in history and in political science, that originalism is a value-based political practice that many in the conservative legal movement have employed to pursue its goals. Memory Games opens in a legal realist account of the different ways in which people in the academy, in politics, and in judging inhabit originalism, and observes that Dobbs is the realization of the political practice of originalism and not the result of applying a value-neutral interpretive method. So here, ridiculously, I'm going to try a two-paragraph summary. So Memory Games shows how originalism grew during the Reagan years in a backlash to the decisions of the Warren and Burger courts. As Genevieve observed yesterday and Nelson today, appeals to the past can be disruptors in the service of constitutional change, discrediting select lines of cases. Reagan was elected, realigning a coalition of voters who were concerned about questions of race, religion, gender, and sexuality, and promised voters he would appoint judges who respected faith and family values. Appealing to the memory of the founding, Attorney General Meese's speeches on the, quote, jurisprudence of original intention insisted that reversing targeted decisions of the Warren and Burger Court, Roe prominent among them, would cleanse constitutional law of politics. These claims on what I call constitutional memory help transmute constitutional politics of the conservative legal movement into claims about constitutional law. So, originalism has a life in politics before it's significantly represented in the academy or on the bench. I note that at lunch, Will and I, who go back a ways, announced that politics was not the topics of the conference. That was for next year, perhaps. But if originalism is going to separate law from politics, how can a discussion of politics not be included in a discussion of originalism? How are we to understand what the role of history is in constitutional reasoning. So I'm now going to observe that in the article, I note that Alito began his career working for Roe's reversal in the Meese Justice Department, and in Memory Games, I analyzed the Dobbs opinion as an expression of what I've been calling the political practice of originalism, living constitutionalism not simply in Larry Solom's sense that Dobbs is doctrinally based, but in the deeper sense that Dobbs's claims about history are value-based. The appeal to the constitutional memory of 1868 enforces family values politics of 1986 in the last 40 years, threatening many of the same lines of cases targeted for reversal by the architects of originalism in the Reagan administration. The article then offers several reasons why ventriloquizing values in this way is anti-democratic. So now I want to talk to you about the prequel of this article on which I'm working now, and it's looking at the roots of originalism and of Dobbs's history and tradition, a standard in the decades before the Reagan administration. So in Dobbs, the Roberts Court repeatedly asserted that in overturning Roe was acting as the Warren Court had in overturning Plessy, that Dobbs was like Brown. Justice Alito asserted that in daring to break with past precedent, as Brown had, Dobbs ended pernicious judicial lawmaking and restored democracy to the states. So in this forthcoming paper, I offer a different account of the relationship between Dobbs and Brown, and thus of the relationship between Dobbs and democracy. In Dobbs, again, history is a disruptor. The court justified reversing Roe by changing the court's longstanding interpretation of the 14th Amendment's liberty guarantee, breaking even with Glucksberg, which in fact recognized abortion and Casey as protected liberties. Dobbs determined that the liberty Roe protected was not part of the nation's history and traditions by counting the number of states that criminalized abortion at the time of the 14th Amendment's ratification. Recall this focus on state counting in 1868 as one of the originalist elements in Dobbs that Professor Barnett and Solom identified. I fill out the Dobbs-Brown analogy by showing that Dobbs employed a method of interpreting the 14th Amendment that Plessy's defenders employed when they counted states that segregated education at the time of the amendment's ratification. In 1952, in Briggs versus Elliott, John Davis is arguing for South Carolina against Thurgood Marshall and demonstrated framers' intent by counting states that segregated education in 1868. Once Brown was decided, the authors of the Southern Manifesto employed this method of interpreting the amendment. The manifesto famously declared, "The Constitution does not mention education." Recall this textualist claim in Dobbs. Neither does the 14th Amendment. The debates preceding the submission of this amendment clearly show there was no intent that the amendment should affect systems of education maintained by the states. When the amendment was adopted in 1868, this is still the Southern Manifesto, there were 37 states of the Union. Every one of the 26 states that had any substantial racial differences either approved of the operation of segregated schools in existence or subsequently established them by the same lawmaking body which considered the 14th Amendment. The Southern Manifesto relied upon state counting in 1868 to prove the 14th Amendment's original intent. That method, indeed the manifesto's precise tabulation of states, resurfaced in almost an uncanny way in Dobbs, where the court observed that this is Dobbs, by 1868, the vast majority of states criminalized abortion at all stages of pregnancy, close quote. And it emphasized, quote, in 26 out of 37 states, states prohibited abortion before quickening. I note that Aaron Tang has questioned or shown reason to believe the count is in fact inaccurate, but the numbers in the opinions are eerily the same. So how did counting states at the time of the 14th Amendment's ratification jump the tracks from an argument that limited the meaning of equal protection in Brown to an argument limiting the meaning of the due process guarantee in Dobbs? There's one prominent moment where this method of interpreting the 14th Amendment traveled to the abortion debate, and that is in Justice William Rehnquist's dissent in Roe. Rehnquist's dissent counted state practice in 1868 to argue that Roe was contrary to the American traditions and to, quote, the intent of the drafters of the 14th Amendment, close quote. This was the same method of showing intent popularized in the defense of Plessy. Where might Rehnquist have learned it? Only the year before publication of his Roe dissent, Rehnquist's confirmation was engulfed in conflict over news of a memo that Rehnquist wrote clerking for Justice Jackson during the 1952 term, a memo in which Rehnquist argued that Plessy was, quote, right and should be affirmed, close quote. Rehnquist's memo did not employ state counting, but it did focus on John Davis and Thurgood Marshall's oral argument in Briggs and defended Plessy, suggesting that a decision striking down segregation would be illegitimate like Lochner. So Justice Rehnquist drew on claims about original intention, state counting in 1868, and Lochner to attack Roe in his dissent. This is how state counting in 1868 jumped the track to the abortion context, spreading in the Reagan years, including into Charles Freed's 1985 brief for the administration seeking Roe's reversal, and in 1986 into the majority opinion in Bowers versus Hardwick. So what is at stake in surfacing this history? First, it illuminates the power of constitutional memory. Imagine if the Dobbs Court had said, we reject the modes of determining history and tradition under the 14th Amendment's liberty guarantee that the court employed in Roe, in Casey, and Lawrence, and Obergefell. We find our authority to reverse Roe in the method of interpreting the 14th Amendment that the Southern Manifesto employed to defend segregation and Plessy. That, too, would state Dobbs' relation to Brown, but would it imbue the court's decision with the same authority? The court's claim that Dobbs is like Brown demonstrates what I call the politics of constitutional memory. Appeals to the past in legal argument seek to legitimate the exercise of public power, and to do so, they make claims about history that may be true, false, or, as they so often are, selective. Dobbs' claim about its relationship to Brown is wildly selective. Second, scrutinizing Dobbs' relation to Brown reveals the roots of the political practice of originalism in the defense of racial segregation. Scholars of American political development, including Keith Whittington here, on the new originalism, or Ken Kirsch or Calvin Terbeek, reason about originalism in a wider social field, attentive to politics and institutions, where one can see that interpretive methods evolve in response to changing circumstances. Originalism has a history. As my work shows, originalism evolved in its targets as well as its methods. When it was no longer politically acceptable openly to attack Brown, originalism shifted its target of critique away from Brown and towards Roe and a series of other cases which I discuss in Memory Games. Mies changed positions on whether to attack incorporation. It's another rich example which Calvin Terbeek has written about. Third, for me, and most importantly, this history of Dobbs' method changes the questions we ask about Dobbs' claim that overturning Roe protects democracy. Consider the structural values the method serves. Fidelity to original intent, identified by counting state laws, defines democracy through the lens of federalism, majoritarianism, and tradition. A court vindicating democracy in this way will defer to a state's prerogative to enforce the customs of the majority against the minority. This is an understanding of democracy more like the account defended in Plessy than in Caroline Products footnote 4 or in Brown itself, decisions that make majoritarianism constitutionally respect-worthy by protecting the infrastructure of democratic participation. When we recognize the thin conception of democracy Dobbs serves, democracy as non-interference, we recognize the states' rights roots of the politics that Dobbs sanctioned in Mississippi and other banning states, and the targeted and coercive forms of protecting life they practice with scant community support for pregnant persons coerced. Our equal protection amicus in Dobbs provides a glimpse of why no Mississippi legislators of color voted for the 15-week ban upheld in Dobbs, which if I had time, I would discuss. But Dobbs says that the Constitution's indifferent to these coercive forms of state action and the injuries they inflict. So Memory Games ends in a call for the democratization of constitutional memory. What sources do we consult, and whose voices do we elevate when we make claims about the history of we the people? Protests of state effort to compel reproduction played a role in the passage of the 13th and 14th Amendments, although we haven't heard about it today. There's a reason for that. I would expand our account of American traditions and of the vernacular of liberty to include the voices of the disfranchised who resisted control of reproduction and slavery, as well as the new forms of control on the reproduction of free citizens, including Comstock, that escalated during Reconstruction. By including the disfranchised, we can see that Americans have long-standing traditions of resisting reproductive control, asserted in struggles over slavery and suffrage in the 19th century, and expressed in new forms in the 20th century in contests over contraception, abortion, and sterilization. Thank you.
Okay, thank you to all of you. I want to take a couple minutes and give you a chance to engage with each other, and if there are any thoughts or reactions you had in response to each other's papers.
Wonderful, wonderful panel, gosh. Just some brief things. I had a long conversation between Elon and myself regarding incorporation of the Bill of Rights. Elon, as I understand your point, that privileges or immunities, the statement to abridge, no state shall abridge privileges or immunities means to deny equal treatment, something along those lines. I simply find that to be too narrow. I don't find that in the historical materials. You have, it shall not abridge freedom of speech in the original First Amendment, and that was treated as a substantive right that the Republicans knew Southern states were denying to everybody, and that was substantively wrong. But that turns into an analysis of the empirical evidence. In terms of whether or not my theory would get us to the Civil Rights Act, you don't start. A big problem with a lot of historical literature in my 14th Amendment literature in my mind is that it starts with assertions about the Civil Rights Act of 1866, something along the lines of, okay, before we begin, the Civil Rights Act really controls the meaning of the 14th Amendment. So let's learn about the Civil Rights Act and go on from there. That isn't my approach. You start with the 14th Amendment by starting with the 14th Amendment. Bingham was drafting it at the same time that they were drafting the Civil Rights Act. They were on separate tracks. They weren't responsive to each other at all. Bingham didn't even support the Civil Rights Act. There is a relationship, but I think you really get into trouble if you use the tail of the Civil Rights Act to try and control your understanding of the Privileges or Immunities Clause. In the end, I think that you're going to get a lot of the Civil Rights Act protections for persons by way of the Equal Protection Clause. That really was a protection from private violence, really was a big part of what they were trying to do in the Civil Rights Act. And then the general approach to equal civil rights, I think you're going to find in the State Citizenship Clause. So whether or not I can get the Civil Rights Act into the Privileges or Immunities Clause, there are other clauses that I think Republicans knew would pretty much cover the territory and covered it sufficiently when they repassed the Civil Rights Act in 1870. And then Larry, just briefly, because this is an ongoing discussion of slaughterhouse. Some of us are going to take this conversation to Princeton in the fall. Thank you so much for supporting slaughterhouse. At least it opens up that particular door. Miller's list of the kinds of things that are protected by privileges or immunities, something that I'm going to continue to talk about in some articles I'm writing right now and that I'll talk at the later conference. That list all involves enumerated powers and enumerated rights. This is something that I think people have not really recognized in Miller's list of what actually is being protected. He's talking about what are states not allowed to abridge in terms of privileges or immunities of citizens in the United States. And he begins by citing his own previous opinions having to do with states not being allowed to interfere with federal operations and federal institutions. These are all in the line of McCulloch against Maryland. And so states can't prevent people from finding their way to federal offices or federal institutions. States can't interfere with the federal government's regulation of interstate commerce and the channels of commerce and things along those lines. So yeah, Congress can pass laws through its enumerated powers that states cannot abridge, because those laws protecting the people of the United States passed by way of enumerated powers are part of the people's privileges or immunities, along with those specific rights listed in the Constitution, and Miller's list includes First Amendment rights. Now, whether or not Miller was thinking about incorporating the Bill of Rights, we can talk about that, but nothing in that list calls into question the incorporation of the Bill of Rights, and I think it very nicely dovetails onto my theory that privileges or immunities must find some type of purchase in an enumerated text in the Constitution. And then finally, I know that Riva and I have very different approaches to originalism, but I simply want to strongly support the idea of doing additional research in the 14th Amendment and bringing new voices into that conversation. There's an extraordinary history that people like Kate Mazur and others have done regarding the Black American struggle for civil rights prior to the Civil War. I think that should feed into our understanding of the equal rights of citizenship. You have the colored conventions that are discussing basic constitutional rights and political and the rights of suffrage. These are all voices that I think have not had adequate play in our historical analysis of the 14th Amendment. So I think that call is exactly right.
I don't have I have reactions, but I'll limit myself to a question for Larry and a question for Riva, if that works. Larry, I haven't looked at Nico's paper in a while, and I don't know if yours talks about this, but the first draft of the 14th Amendment would have provided Congress with the power to make all laws necessary and proper, right, to protect life, liberty, and property in the states. This was objected to quite forcefully by Hale, Hotchkiss, Stewart in the Senate. They said, the objective here is to not discriminate on the basis of race, right? And Bingham didn't deny that. But this amendment, this draft, makes it look as though Congress has the power to make uniform legislation with respect to life, liberty, and property in all the states. And why don't we want that? Because someday the Democrats will take over, and I don't want rebel law uniform throughout the Union, right? And so I guess my question is, under your reading, is the effect of the Privileges or Immunities Clause exactly what that first draft would have been, that Hotchkiss and Hale and Stewart rejected? Would it give Congress the power to make uniform law with respect to contract, property, marriage, and so on in all the states, because those are all within privileges and immunities, right? And so I guess that's my question for you. And with Riva, I guess the Southern Manifesto, as distasteful as it is, it's like, that's exactly the argument I would have made, right? If I was arguing against Brown, I would say, yeah, look, the historical practices was uniformly consistent after the 14th Amendment was enacted. That's evidence that the 14th Amendment didn't prohibit it. And I think that's a good methodological argument. And I guess my question is, I don't know if it was Andy Koppelman or Daryl, I don't remember who said it before, but there are traditions that a text was intended to abrogate and obliterate, and then there are traditions that that it wasn't, and whose persistence might speak to meaning. And isn't the difference between and I'm just asking, isn't a plausible distinction between the states that allowed abortions and the segregation is that at least people thought that segregation was, that the clause applied to the question, maybe segregation was or wasn't an abridgment, but it was at least contested, and it was within the realm of possible meanings and understandings, that those practices were targeted by this. And as Michael McConnell has written, the reason that those practices never went away is because the Democrats won. They won the election, and that's why. So it's like a historical and sociological explanation. So I guess I'm wondering if that's a way to think about these different invocations of tradition.
Thank you, and I apologize. I didn't thank, like everybody else did, before I spoke, Michael and the Center for inviting me, because I've really enjoyed re-engaging these issues. Let me start with Kurt, because Kurt's magnificent book about the Privileges or Immunities Clause makes an extraordinarily compelling case that at least if you're Bingham and Trumbull, you have a conception of the scope of the Privileges or Immunities Clause which is much narrower than the conception that Elon was advancing, or even the conception I was advancing. And so I would stipulate with you that if the meaning is the meaning in the head of Bingham and Trumbull, then it is just slaughterhouse and nothing more. Like, that is it. Because we both agree that slaughterhouse suggested the incorporation of the rights that the Bill of Rights stood for, so that too should be part of privileges or immunities. So it would be a substantially more powerful clause than it is, but it wouldn't be a perpetual source of new rights to be recognized, whether by the courts or by Congress. But the puzzle, I guess, for me is is that really the way to read the text? Because we know over the 150 some years, very few people have come to that very clear understanding. I find your reading consistent about compelling about Bingham and Trumbull. But many people read it in a way that sees privileges or immunities as evoking the Corfield versus Coriell conception, and therefore an invitation to do much more than just the narrow conceptions that were originally given. So I guess I'd just ask you how we think about how we should interpret the clause, given it's maybe not right that it's what's in the head of two guys that determines the scope of the clause. And then to build on it a little bit, Elon, in response, yeah, so what's striking about Nico's paper, and also what I've written, is if we agree that it's not the case that no new privileges or immunities can be elevated above the static list that Slaughterhouse seems to invoke, if we agree that none is not the right answer, certainly all possible privileges or immunities is also not the right answer. And the way to see that, I think the way to see that Slaughterhouse is speaking about something in the middle is to read the part of the Slaughterhouse opinion which seems to reject the idea that Congress has any power to recognize privileges or immunities at all. Because, so they say, what's the purpose of the 14th Amendment? Was it the purpose of the 14th Amendment by the simple declaration that no state should make any law to enforce any law that shall abridge the privileges or immunities of citizens of the United States, to transfer the security and protection of all the civil rights which we have mentioned from the states to the federal government? And later it says, was it intended to bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the states? Nico and I both say, that's right, it wasn't intended to give you the scope over all. All is not the answer. But again, if we don't accept the narrow interpretation of the 1866/1870 statute that Kurt has given us a way to see in the minds of Bingham and Trumbull, it seems like the 1866/70 statute is a recognition that there's some. Because those rights, unless you see them, as I think you argue compellingly, this is what Bingham and Trumbull thought, you see them as kind of expressions of the due process idea. Those rights more naturally seem to be exactly the sort of rights that Corfield was talking about, so there was some scope to elevating new rights by Congress. And what I'm saying is, Slaughterhouse recognizes this is going to be an ongoing struggle, and rather than putting on the court the duty of articulating unenumerated rights, which is not obviously a non-starter, and Miller was so frustrated with the amount of work the court had to do without any clerks, and that the number of cases was piling up and up. So he didn't want any of that unenumerated rights stuff. But I think he also didn't want to say none. And I think 1866/70 is like the camel's nose under the tent. Nico, didn't think it got you a huge amount. He didn't think it got you the abortion right, at least in that paper, although now I think he's rethinking that. But that I think is the scope of what's interesting debate about this. And Riva, I've loved your paper and the extension you've made on it. I would just suggest you add one more bit to it, because it's kind of related to what's frustrating to me about originalism debates today. Because if we recognize, originalism grew out of a conservative legal movement whose objective was to shut courts down. So they, were very Therian in their approach. It was like, you have no right to overturn the actions of a legislature unless you've got a clear basis for doing so. And we're going to give you a method for deciding what that clear basis is. And a little bit ignorant about how history works, but they thought that history would give them a clear method for identifying which things ought to be overturned by legislatures. This was a way to make courts less relevant. Now, in the modern version of originalism, that Therian part has been thrown out the window. And now we have a new method which is being used not to shut courts down, but to empower courts. And empower courts, I think your analysis would elevate the fact, empower courts just at the point when we're happier about the mix of who's on those courts than we were maybe at the time that we were trying to shut the courts down. So this is, I think there's an important external reason to invigorate the understanding of the political contest here, and that's one part of the originalism story I think we shouldn't leave unremarked.
Wow, okay, this is a wild panel, and I actually am looking forward to having the group in the conversation. I think that sort of to thematize one feature of my argument from actually the portion of the paper I was least spoke from, which is what I was calling democratizing memory, I would say, and Kurt and others on the panel know this, that when I think about privileges and immunities, I also think about a very key claim that was advanced through the appeal to the privileges or immunities clause, and that was women's suffrage. And I guess I was saying last night at dinner that one can understand a lot of things about what's going on in Slaughterhouse if one understands the virtual concurrency of the argument in Bradwell and in Slaughterhouse. And we have, I think, a richer context for asking what's at stake in inhabiting and identifying this history if we give a thicker account of the contests in which these conversations were engaged, and then ask what is at stake in essentially identifying, as we observed earlier today, intermittently with this law as our law, as we toggle back and forth between precedent-based reasoning and then return to history. And my concern about employment of this method is that it will take virtual representation, which was essentially the brew that many in this country were given for a very, 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 very long time, and build up its role in our current legal order, unless we're quite self-conscious about the ways in which we make claims on this past history and who was shaping law then, who was we the people then, and who was we the people now, and what are our practices of making claims on these memories, what work are they performing today? And we could be reenacting past exclusions if we're not mindful about who are the authorized speakers at the table. And that's just a methodological puzzle I want to put on the table. Of course, we're all capable of identifying with various members of the community to speak community norms. But when there's systematic, meaningful, structural exclusions on the demos over centuries, one needs to be mindful of them if one wants to take prior law and, on the basis of prior values, tie it back to past legal determinations. So I'm mindful of the cases in which this is happening and the cases in which it's not happening. I'd invite us to be so. I understand what is happening, what the wonderful paper that Larry has presented is inviting us to inhabit a different time, as you're saying, both in the 19th and the 20th century, in which we could say that we want to look to politics for determinations of matters that are dividing us, and not so much to courts. And that's one reason to really inhabit our history generously, to remember that we're not always in our current really jurocentric situation, but as much of my earlier work invites, that there are epochs and eras in which constitutional articulation is happening through the representative branches of government, and I take that to be an important reminder of yours and Nico's and Daphna's work. And I affirm that, you know. But I also am aware that this appeal to the past is, as Genevieve and Nelson and others were saying, it's a disruptor. You know, it's inviting us to be mindful of the fact, even as Judd would point out, that ways of understanding how law is to be enforced 100, 200 years ago were not necessarily the ways that we've become accustomed to today. And so we ought to be thinking exactly how selectively and how capaciously we're looking backwards. And, you know, I think every one of these turns and the fights over their relevance is generative in that way. So this is not a resisting claim, but just a claim that we ought to be mindful that this is about an argument with one another in which we're looking backwards, and part of our looking backwards is through very contemporary disagreements. And I don't want to keep going on. I'd rather have the audience come in.
Okay, great. Well, let's turn it over to the audience. And if there are people who, are we having them come up to the microphone, Rebecca? Or?
Please.
Okay.
So thank you so much for the interesting discussion. I have a question for the panel that actually links to a presentation that he organized 2 weeks ago with Danielle Allen. She had done led a work to, because I'm going to address the elephant in the room. The reason we are having this is because we have lifelong tenures in the US Supreme Court, and when a particular political view of this Constitution wins, they defend their view, which is right now historicity. When the other side wins, they defend the living Constitution. What about putting limits to the terms of the US Supreme Court? And that will actually fix everything, including the we the people. The meaning of the we the people will be those justices will rotate. They will be, aware of what is going on with the people, and we the people will be now, as opposed to having to analyze psychologically what Alito thinks, what he doesn't think. And I say that as somebody who is pro-life and who is happy with the Dobbs decision. I think that Roe v. Wade was wrongly decided. I have a PhD in electrical engineering from Stanford. Life begins at conception. But that aside, I think that all these debates come from that. So I would like to hear your thoughts about that. Thank you.
The first thing I would say is I'm confident that whatever reform you have in mind will not fix everything, because a lot of smart people have spent a lot of time on the Supreme Court Commission, testifying to the Supreme Court Commission, and whatever it is will not fix everything. Having said that, I've supported 18-year term limits. There are downsides to it, but there are also upsides to it. But I'll just leave it there. That your point is well taken. But whatever solution you have in mind will have problems.
Yeah, if you do the term limits, I think we should do it through what I call the death lottery. So the way the death lottery works is that, give them a fixed amount guaranteed. So maybe that's 15 years or something. And then afterwards, their name goes into a lottery. And on January 1st every year, you spin the lottery and you pull the ball out. And if your name is on the ball, then you've got to resign by the end of that year. But this way, there's no end game that you can play. You don't know when you're going to be kicked off, so you're not going to be making the deals with the next group that you might be dealing with. And it would be a fun thing to watch on January 1st.
I was death lottery made me expect a different ending to that.
Yeah, I believe we have a death lottery for the justices. My question is, who on the panel thinks that Chief Justice Chase was right to dissent in Bradwell versus Illinois, and why or why not?
And what was his reasoning in that opinion?
Well, we don't know, so I'm hoping you'll tell me.
Well, it's a little bit of an obscure, for some people, obscure reference that Bradwell's handed down the day after Slaughterhouse, right? And you had the dissenters who had said there's an unenumerated right to economic liberty, darn it, and it should go to those white butchers. And then the next day, you have a claim that a woman should have a right to practice law. And they said, oh, that stuff we said yesterday. No, Justice Miller, because Miller had taken the position that there were no unenumerated privileges or immunities, his opinion was simply, see our decision in Slaughterhouse. There are no unenumerated economic rights. It was the dissenters of Slaughterhouse that had to go further and explain why they're going to deny this woman her equal right to practice her trade, and that gets to a rather infamous opinion regarding the status and capabilities of women. Chase dissents, but Will, I don't know if I can quote it correctly, but something like dissent, but not for any of the reasons of the other opinions, and that's it. And then he dies. Right. So he's not agreeing with anyone. Randy Barnett has wondered about this, whether or not he would have developed a broader, more robust privileges or immunities understanding. I'm just going to presume that he would have developed a theory of equal state citizenship and would have followed my approach. So that's my preference for what he would have done.
Are you?
I'm happy to dodge.
Okay. So now that I have tenure, I'm going to usurp Michael and ask the question as commentator, which is one of the questions I feel like has been lurking over the conference more generally, and one of the questions I think it's great to have people with mixed methods on the panel and at the conference more generally, is really Larry's question about sort of the choral analogy. In other words, ripping stuff out of the past and thinking about how to put it into the present, right? And how we go about doing that. And I thought there was a rich sort of tensions among your perspectives. Actually, in the written paper, Larry and Riva, there's a debate about what do we do with the pastness of the past, and Riva sort of saying, look, we should acknowledge that this is a politics of constitutional memory and fight back with a counter politics, and Larry sort of defending a good faith interpretation, even if it is engaged in bad faith. So I thought there was a rich interpretive tension among the two of you about how to react to precisely this challenge of translation. And then Elon and Kurt, I'm curious what your thoughts are on, I mean, one of the things that's striking about your arguments is that they are really about, thinking carefully about what did people think in the late 19th century. But what do we do we start from the presumption that what they thought in the late 19th century should govern now? I mean, I realize that, of course, is the premise of a lot of originalism, but I also think there's another question, which is, how do we go about making that work of translation? I mean, is that even possible to implement now? So I'll invite you to take that up briefly so that we get to Michael, but I'm curious your thoughts on this.
Well, I would say, so I appreciate framing the question like that because, I feel like the only unaccepted originalist in the school of originalists, because I am, in a very important sense, Michael has kindly acknowledged this, a kind of originalist, but I'm a two-step originalist. So unlike the originalists who say, here's what it said and meant, and so therefore that's what we do, I want to ask the question, I want to say, okay, here's what it said and meant, and how do we carry it to where we are today? And what can we not do anymore that they could have done before? And I think this latent debate that I've had with Will and with Steve many times about what the significance of Erie is in the context of the debate about general law is a really great example of this kind of limit. Because if you're in a legal culture where you're able to play the general law game well, and it feels like natural to you, and you know what you're doing is you're articulating these common law principles, and everybody looks at you and they see you playing the same game, the capacity to play that game is obviously different from the world we live in today, where every time a judge makes a common law rule, somebody says that's because she's a Republican or that's because he's a Democrat. The point is, the culture makes it possible in 1850 to see these moves as something other than politics in a way that the culture today makes them see like politics. And my best, the evidence I would offer as Exhibit 1 here is the quintessential originalist, Justice Scalia. So when Justice Scalia, in his Sousa concurrence, I guess, / dissent, is talking about about common law, he's quite happy to say, yeah, the framers had a different conception of common law than we do, the old conception and the new conception, and for him it was obvious. We had to follow the new conception. And you might have said to him, and I never got a chance to ask him directly, why do you follow the new conception of the common law? Why don't you go back to the old conception of the common law? Isn't that what an originalist should do? And I think the fact that he doesn't do it reveals that he too accepts there's a constraint on how much you can do in the face of what we all now take as true. I just put it like, you can't spit in the face of what everybody believes is true. And that's a real constraint to the capacity to translate. So it's always translation subject to a constraint like that, and I think that constraint is very real in the context of what we can do for the 14th Amendment.
So I think after long-running conversations with my pal Jack Balkin, running over more than years, I can say actually many of my remarks come from a paper that I actually never published on the occasion of his Living Originalism book. I could say that we just have different responses about the stakes for responding to originalist argument given its evident pedigree and genesis. And I don't want to, I've thought about them actually in reading Larry's work, and I don't want to go into the question about the feasibility of moving certain audiences and whether one can do it systematically or only episodically. I've really tried to think about whether it was a voice in which I chose to speak and reason, and what would be the stakes of my doing so. And I've thought about this with a really robust sense of all of the ways in my work in which I've looked to the past and to past practice as a way of talking to my community today about the stakes of who we are and what we are to do. And so it's not that I'm opposed to historicism or I'm opposed to understanding the history of the ratification of the amendments or to revisiting them. To the contrary, I think it's a rich practice and part of my teaching practice and a practice that I would celebrate, but I don't want to do this in a way that's constrained by certain rules of the game that lead me to disattend to certain really critical features of the landscape. And in memory games, I offer 3 different ways of talking about what I call the anti-democratic logic of the Dobbs opinion. One, that it targets what I call equal participation rights, which if we had a time to talk about, I would, but the kind of rights that it's opposed to. But 2, that it calls on imagined communities that have embedded within them norms and hierarchies that are not interrogated by the method, that are actually just simply seem to cluster around the method in an unassumed way. And 3, that it presents the past as a fact that disables, that conceals the element of judgment in choosing which paths to visit, and therefore buries the value claims in a way that the public can't grasp and contest. And it might be that that's the most concerning to me of all, that people should have an opportunity to engage with the courts and lawgivers that enunciate their norms and their law in a way that they're able to understand the stakes. It was at stake, actually, in my exchange with Genevieve yesterday. And so I view as just utterly robust the doing of this thing, but holding myself 1 foot in and 1 foot out of the practice. And I want to say again to you all that these claims on the past are disruptors. They can be disruptors in the service of equality or inequality. There's so many forms of claims on what I'm calling memory, but they're not standing out, they're not purely fact-based when we're arguing with one another about what we're to do in this way. And I invite the group to be mindful of that in as participatory way as I can. My last word here, as an ethical agent, and this is a sort of source of a long-running conversation I've actually had with my pal Robert, I can't but help myself, see myself as a cause and an effect, to see myself in history at the same time that I'm acting in history, and to want always to be in some critical relationship to my own actions and judgments, and to understand the ways in which I'm likely imbuing values in the things that I'm doing. And there's something about this way of proceeding that is privileging people's refusal to see their own roles and positions in a form that I find unnerving. My best understanding of the practice that Will is describing is insight and living constitutionalism, and only by a judge not recognizing that the performance of deference is itself the performance of discretion and judgment does that possibility of understanding role disappear. And I'll stop there.
Can I take, why don't we have you tell me later, and we'll have Michael get his question in.
Well, in the minute remaining, I'll try to be very fast. As I hear it, Kurt tries to prevent a runaway privileges and immunities clause by limiting it to enumerated rights, mostly in the first 8 amendments. Ilan tries to prevent a runaway privileges and immunities by limiting it to inequality claims. But there is a third path, which is to limit it according to firmly embedded, long-standing practices. I think this is really what Will may have been getting at, and my question was going to be, is that actually a faithful interpretation of Corfield versus Coriel's statement of its methodology, which begins by talking about, both a horizontal consensus among jurisdictions, and then also a length of time dimension, and I'm just asking, is Glucksberg a reasonable modern translation of Corfield versus Coriell?
Before you answer, do you think you can do your question very quickly?
Sure.
Great.
Yeah, it's very straightforward. So one of the things I love about this conference is being able to think about this, approach of history and traditions across doctrines, and this, so I'm curious about equal protection. Sharif Gurgis sort of surveys the field of the use of this kind of language in Supreme Court opinions and finds it's pervasive except in equal protection. So I'm just curious what the panelists make of that, and Reva's comments about comparisons to equal protection cases raises this kind of question in my mind. And why do we see this? And maybe it's because the equal protection clause is designed to disrupt traditions, but I think that's a pretty unsatisfying explanation. I don't think the court necessarily would buy this. So the puzzle remains why is it anomalous?
Okay, so why don't I give Elon and Kurt, since you didn't have a chance to speak earlier, you get 30 seconds apiece.
It's impossible. I was going to try to answer Will's, yours, and Michael's questions in one kind of statement, which is I don't think longstanding tradition does any work here, because contract property is the right to get an abortion and limits on that limiting a contract right, the contract for health services. The question is, what is an abridgment? And that's my answer to Will's question as well, and to Greg's question, because whether that was right or not, and I have an argument for that, but I'll dodge that. In 1970, it was absolutely wrong. Why? Because what is an abridgment? How do you know if the states can regulate the right to contract and property and guns and speech, but they can't abridge that right? How do we know what is a regulation of a right versus what's an abridgment? And the short answer is the purported regulation has to be reasonably related to the purpose of the right. That's how we know the black codes were unconstitutional, because being black has nothing to do with why we have contract rights or property rights, and it's why a gay code would be equally unconstitutional without needing to find that gay persons are a suspect class, because being gay has nothing to do with contract or property rights. Now, is it therefore limiting women from practicing certain occupations, engaging in economic rights, an abridgment, right, or reasonable regulation of the right, whatever the answer was in 1870, after the 19th Amendment with the grant of political rights, which was the greater rights than the economic rights and other privileges and immunities, the answer was obvious, and it's what Justice Sutherland said in dissent in Adkins v. Children's Hospital. Now that we have the 19th Amendment, now that women are fully brought into the regime, if men can freely contract for whatever wages they want, then so can women, and I think that's the answer to all three questions that I was asked.
Kurt?
Again, my thanks to everyone here. What an extraordinary conference.
I'm thankful too, by the way.
Michael, I think that if you view, as many scholars do, if you view the Privileges or Immunities Clause as transforming Coriell's state-secured rights into national substantive rights, then I think Glucksberg is a fair application of that approach. I simply don't see the evidence for the transformation.
Okay, thank you all, and thank you to the panel.
All right.